Good afternoon, everyone. Welcome to another live question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru, Tumarkin. I'm located here in Ottawa, and I'm here for the next half an hour to answer all of your questions. So send in your questions related to anything workplace law, employment law, issues you're having in the workplace, whether it be regarding a termination, severance pay, termination entitlements, changes to your conditions of work as an employee, health and safety issues, whatever the case may be. As I said, I'm here for the next 30 minutes or so to answer any and all of your questions. As always, I have a list of topics prepared to discuss. If we have time, usually we don't get through that list. Today is a Friday before a long weekend, so we'll see. It might be a little quieter today. We might have more time to get through some of these topics, but I'd much rather be answering your questions. So please send in your questions, and we will get to as many as we possibly can. I see one has come in already, so I'll get to that question right away. I have a question from Bill on YouTube, who says, I am on short-term disability. My line manager and HR disabled my company accounts, not email, no SharePoint, no Teams, no anything internal I can see and use. Is this called discrimination? Bill, great question. The short answer is no, it's not discrimination. And this kind of leads to a broader topic of a medical leave. So when you're on a medical leave, you're on a leave from your work, you're still an employee, you still continue to accrue service, you would still have your, for example, health and dental benefits in place, you would basically have everything in place, still be an employee, but be on medical leave. During that time, it is very common, and it's actually advisable for employers to remove your access from your work accounts. That's because you shouldn't be working while you're on medical leave. When you're on medical leave as an employee, it's because you cannot work. And I can tell you, I've spoken to many employees who, even on medical leave, still feel the pressure to work, to check their emails, and have difficulty kind of letting go because they're worried that something might happen. But that is not the expectation as an employee on medical leave. The expectation is that you focus on your treatment, on your health, on getting better so that you can return to work and continue to be healthy at work and not have any further issues. And so it is perfectly normal and perfectly standard for an employer to remove your access, remove an employee's access from their work email accounts while they are on a leave. We're talking about medical leave, but it could be any legally protected leave. For example, parental leave. If you're on parental leave, if you're on maternity leave, parental leave of any kind, the same thing will occur. An employer will remove your access to those accounts because you're not actually working. You're still an employee. The fact that you've had your access to those accounts removed doesn't mean that you've been let go, doesn't mean that you're no longer an employee. It just means that you're on leave, and so you don't need access to those accounts. And then when you return to work after any of these protected leaves, medical leave, parental leave, just to name a couple, then all of the access to your accounts will be reinstated. So that's perfectly normal. It's not a situation of unlawful discrimination against you because you're on medical leave. These are standard practices that most employers will put in place. And I would even go a step further and say, as an employer, it's something that you should be doing to ensure that there aren't any issues with employees working while they're on medical leave or accessing work accounts, for example. There should be, what I would call kind of a clean break when an employee is on a medical leave. It's a temporary clean break, but a clean break nonetheless, where you're having, an employee is on medical leave, you're focusing on your recovery, you're not supposed to be working. And then the other issue is the employer should not be contacting the employee while they're on medical leave as well to discuss work, to ask about different things related to work. There can be, conversations or correspondence about the employee's current medical state. So maybe an update. If you've been on medical leave for a while as an employee, your employer might check in to see when you think you might be able to return, if there's any sort of update, to check in about your return to work date. That's correspondence that would be appropriate in certain circumstances, but other than that, there shouldn't be much communication going on between the employee and the employer during a medical leave, during a parental leave, any of the legally protected leaves. So I hope that answers your question, Bill. The other thing that I should mention, just related to Bill's question, is something that I've had come up a couple of times in the last few weeks. So I actually had it on my list of things to talk about today, and that's with respect to medical leave specifically. When we often refer to medical leave, sometimes we say, I'm on short-term disability leave, or I'm on long-term disability leave. Like Bill did in his question, Bill said, I'm on short-term disability. We often conflate the medical leave and whether or not we're getting disability benefits. And so that's a really important concept to make sure that as an employer and as an employee, you would understand that they're completely separate things. An employee has a right to go on medical leave if they're medically unable to work. As an employee, you would provide a doctor's note to your employer, providing, supporting the fact that you can't work, that you have to go on a medical leave. If you can provide the approximate time for which you'll be on leave, that's great. Sometimes we're not able to. Sometimes it's going to be something that continues to be monitored by a doctor, and you might not be able to return for a while. That's okay too. But as an employee, you would provide that note and you would be able to go off on your medical leave. While you're on medical leave as an employee, it doesn't mean that you're necessarily going to be paid or receive disability benefits. So this is where it's a separate issue. You would be able to go on medical leave regardless of whether you can get disability benefits. And what I mean by that is, if you have short-term disability policy in place or you have a long-term disability policy in place, you can then apply for those benefits. The insurance provider for the short or long-term disability benefits will assess the claim that you make and will decide whether you're eligible and whether you can receive these benefits. That's separate and apart from whether your doctor has said that you're medically unable to work. An employer has an obligation to accommodate employees up to the point of what's called undue hardship. And so regardless of whether you get disability benefits during your medical leave, you still are able to take a medical leave. Some employees don't have disability benefit policies in place at all. If you're one of those employees where you don't have a disability benefits policy, either through your work or on your own, you can also take out your own personal policies of that nature. If you don't have those policies available to you, then you would be applying for EI sickness benefits, and that's done through Service Canada. Some employees have only long-term disability benefit policies, but they don't have short-term. If you don't have short-term and you only have long-term, same thing applies. You would be applying for EI sickness benefits, and you would be going through that avenue in order to get EI sickness benefits. And then if you're still unable to work once that period expires, then you would be able to apply for long-term disability benefits. So I just wanted to clarify that because I've actually gotten a lot of questions about this in the last few weeks. And it's really important to understand that they're two completely separate things. One is a medical leave and one is eligibility for disability benefits. Separate issues, although they may be happening at the same time, because in order to be eligible for disability benefits, you would first have to be in a situation where you're going off on medical leave. So I hope that helps clarify the issue for those who are watching. I have a couple more questions coming in that I will get to. I have a question from Janine on Facebook, who asks, can my employer shift my schedule from 8 to 4 to 11 to 7? This seems like a huge change, and I worked in this schedule for almost 7 years now. Not sure of the reason for the change. Okay, Janine. So generally speaking, when we're talking about an employer making changes to the terms of someone's employment, there are certain changes that an employer does have the discretion to make. So employers can make certain changes to an employee's terms and conditions of employment. What an employer can't do without an employee's consent is make significant changes to the fundamental terms of the employee's employment. That's where we get into an issue. If the employer is trying to force significant changes on the employee without their consent, and it's a significant change to things like pay, schedule, place of work, those are the kinds of things that could lead to the employee having the ability to refuse and if the employer still forces it on the employee, then you may be able to assert what's called constructive dismissal. A constructive dismissal is something that would occur when an employer is making such a significant change to the terms and conditions of employment that continued employment is no longer possible. And again, that doesn't mean for every change. It has to be a very significant change to the fundamental terms of employment. And so essentially, when something like that is happening and an employee has no choice, the employer is forcing the change on them, you would be able to effectively resign from your employment and treat it as a constructive dismissal, as a termination of your employment. The reason that it's called a constructive dismissal is because the employer is not outright saying, we're letting you go or you're fired, but the end result is the same thing. And so in a situation like yours, Janine, specifically when we're looking at a change in schedule, 8 to 4 to 11 to 7, that is a pretty significant change in terms of those hours. I do think the reason for the change is important, as well as whether it's a permanent change, because that's something else that we look at when we're determining whether the change that the employer is trying to impose would rise to that level of being a potential constructive dismissal or not. It has to be a permanent change as well. So if it is temporary, we look at, okay, how temporary is that change? Is it a couple of weeks? Is it a couple of months? If we're getting into many, many, many months, we're kind of getting into the territory of not so temporary. And so you really want to make sure that you understand why this change is taking place and whether it's permanent or temporary. If it's permanent, depending on the practice, the history here in terms of your employment, there could be an argument here that this is a significant enough change to be able to refuse it. 8 to 4 versus 11 to 7, it is in that area where it can be considered a significant change, but it will also depend on the circumstances. For example, if let's say you're unable to do those hours because you have young children that you need to care for, that will give you an additional reason for why this is too significant of a change. So it really is context specific, but just on its face, 8 to 4 for 7 years, changing it to 11 to 7, that's a pretty significant change. And I do think that you'd be able to possibly have the ability to refuse that, again, depending on the context. There's information that I don't have here, but you certainly have that possibility based on the information provided, Janine. So what I would recommend that you do is find out if it's permanent or temporary, find out the reason, do it quickly, and then get in touch with us so that we can assess your situation further. You can always contact me directly by going to our website, employmentlawyer.ca. All of my contact information is on our website. You can also email us at help@employmentlawyer.ca. So there are different ways you can contact us so that we can assess the situation. The last thing that I'll say about this for you, Janine, and for anybody who's tuning in, if your employer is making changes to the terms and conditions of your employment, you have to address it quickly. Time is of the essence. I cannot stress this enough. If you wait too long and you keep working under the changed terms, you will be deemed to have accepted those changes. Even if you haven't said, yes, I agree, even if you haven't signed anything, just by you continuing to work under the changes, you're deemed to accept them, and then you're stuck with it. And so if there is a question of, is this a significant change or not? Sometimes it's not a significant enough change, but it's still important to speak to a lawyer to make sure and see if this is something that you can refuse or not. And then if you can refuse it, there is a way to go about doing that certainly we can assist you and walk you through. But you have to do it quickly. If you keep working under those changed terms, you're going to be stuck with them. And so that's why I say time is of the essence. If you're going to refuse, if you have the ability from a legal perspective to refuse, you need to do it quickly and always in writing. And so that's why, Janine, I say figure out those few things that we're not sure about, get in touch with us right away so that we can assess the situation for you, and you can make an informed decision on what you want to do. I have a question here from Kyle on YouTube who says, I was let go after almost 15 years due to some obscure company rule that I wasn't even aware of. Can they do this? Okay, this raises a few different things. So first off, an employer has the right to terminate an employee's employment at almost any time and for almost any reason. So from the get-go, can they let you go? Certainly they can. They always have the ability. An employer always has the ability to let somebody go. The question is it a for-cause termination or a without-cause termination? If it's a for-cause termination, the employee is not entitled to receive any severance or any notice. And a without cause termination means the employee is entitled to receive their full severance. Now, just because an employer says they have cause and terminates an employee for cause doesn't mean they actually do. That requires an employment lawyer to have a discussion, to look through what happened, and determine essentially whether cause existed or not. And when we're talking about cause and terminations for cause, in order for there to be cause and for an employee not to be entitled to receive their severance or notice of their termination, there would have to be very serious and willful misconduct. Okay, so very extreme examples would be theft, fraud, physically assaulting someone in the workplace. Those are examples of where cause would exist for a termination and where the employee would not be entitled to receive any notice of their termination or severance. Absent very serious misconduct, it would be a without cause termination. And a without cause termination doesn't mean that there was no reason for the termination, because there's always a reason, whether we agree with it or disagree with it, but there is always a reason. So without cause doesn't mean there was no reason. It just means they didn't have cause. It means you're owed severance. And then it becomes a question of how much severance is owed in this without cause termination. And so for you specifically, Kyle, if there was a rule that you were not aware of, that would be a consideration if you were terminated for cause. If you were terminated for cause because you've breached a rule that you were not aware of, that's something that we would be looking at. Were you not aware of it because you ignored something that they sent you, for example, or did they never bring it to your attention? Is it a rule that they just made up? Is it not in a policy anywhere? If it was in a policy that you've signed or that you were supposed to review, these are all the things that we look at in order to determine whether there was serious misconduct that would justify termination for cause. Most of the time, terminations for cause are very exceptional. So they don't come up very often because it does take quite a serious instance of misconduct to justify a termination for cause. Having said that, it does happen, but we do have to look at the circumstances. So in short, yes, they can let you go. It really will depend on whether they let you go for cause or for not. If they let you go for cause for breaching a company rule, we would have to look at, if you weren't aware of the rule, why weren't you aware of the rule? Was it because the employer didn't bring it to your attention, or was it something more in your control? And then if you were terminated for cause, then yes, the reason for the termination is not something that we would be looking at to determine your severance. If it's a without cause termination, you would be entitled to severance, and then it becomes a question of how much. And that assessment will be based on things like your age and your length of service, among other factors. And so certainly, Kyle, I would recommend that you get in touch with us so we can review the situation with you. If you were let go for cause, it's very important that you speak with an employment lawyer who can go through the situation and assess it, because it may mean the difference between no severance or full severance for you. If you are let go without cause and you were offered a severance package, you should still get it reviewed by an employment lawyer to make sure that it's a reasonable settlement package. It's a reasonable severance package and you're getting what you should be getting. If you're not, we can assist you in pursuing what you should be getting. Okay, I have a couple more questions coming in. I have a question from Lola on Facebook, who says, I was hired on a 1-year contract basis. About 8 months in, I got really ill and had to take leave. I'm now unsure about my prospects returning to the job 2.5 months later. They initially proposed after 1 year I could become full-time, and now I'm not sure. Okay. Okay, so Lola, if you signed a 1-year fixed term contract, the employer doesn't have to continue your employment beyond that 1 year. Usually in a 1-year fixed term contract, the employer will include language that says if we want to continue your employment, we can renew your employment, and they provide a mechanism for how that would work. So usually it's something like both parties have to agree in writing. We have to put it in writing that we're going to continue our employment or renew it, but they don't have to. So it's possible that, if you don't hear from them otherwise, your employment will end when that 1-year fixed term is supposed to end. If, let's say, your employment continues, you haven't signed anything new, you just continue working, you go back to work, you keep working, then your employment is no longer on a fixed term 1-year contract anymore. You've now become an indeterminate permanent employee. Okay, so that's how that would work in terms of whether you continue working past the 1 year or not. Okay, and again, with respect to the full time, certainly it's something that they could propose, it's something that you could discuss, but they don't have to do that. If the term of your contract specifically says it's a 1-year term, at the end of that 1 year, your employment would just automatically end unless you've agreed otherwise, unless the employer has asked you to continue on. Now, if you're returning to work within that 1-year fixed term, which it seems like that's what you're most concerned about, you would have the ability to return to work. So if you're at the 10.5-month mark out of 12, you still have a month and a half left on your contract. You would be going back to work and you would be continuing that contract until the end. The employer has to allow you to return. So just because you went off on a medical leave doesn't mean they can let you go or not allow you to finish that 1 year. They have to at least let you continue to finish that 1 year. So once you're cleared to return to work, you provide a letter from your doctor clearing you to return to work. If you do require any accommodations, if let's say your medical condition requires that you can only work a certain amount of hours a day, or there's other restrictions in place that would require accommodation, then make sure to provide that in detail in a doctor's letter to the employer so that they can properly accommodate your medical restrictions. Otherwise, if you don't need any accommodations, your doctor would clear you to return to work without restriction, and then you would go back to work until at least the end of that 1-year term. And then, as I mentioned before, they may decide they want to keep you on, but they don't have to. They do, however, have to allow you to come back to work within that 1 year. Okay, so if you're clear to return to work, you've been on leave for about 2.5 months. If you've been cleared to return to work, you're going back to work until the end of that 1-year fixed term. And if you do have any issues with that, if let's say they won't let you return or they terminate your contract early, certainly you should get in touch with us at that time. Okay, so I have a question from Kamisha on YouTube who says, can an employer continually reprimand an employee in order to have a case built against them, even if the write-ups and statements are untrue? After I filed an occupational health and safety complaint and the investigation ended, I was terminated 2 weeks later. All right. So in terms of discipline and employee write-ups, when an employee is engaging in misconduct, it is perfectly normal and as an employer advisable to be putting it in writing and outlining the fact that this misconduct occurred and making sure that there's a record of it. In terms of whether it's accurate or not, usually as an employee, you're going to be presented with a written record of, here's what happened, you did this, you did that, please sign here. What you can do as an employee, if you disagree with what is being outlined, is, first of all, you don't have to sign that document. Because if it's not clear whether signing means you agree or not, then you shouldn't sign it. If, let's say, it just indicates you're signing to confirm receipt, then that is okay to sign, as long as it's very clear that you're only signing to confirm, yes, you received this document, but you don't agree with it. The next thing as an employee that you can do if you disagree with a written record of discipline is you can provide your own version in writing. And this is what I recommend to my employee clients all of the time. If you're dealing with a situation where you're being accused of something, you don't agree, or it's not quite exactly the way it actually happened, put your own version of events in writing and send it to your employer, send it to HR, and say, this is actually, from my perspective, what happened. I disagree with the warning I received. I disagree with its contents, and here's why. And you explain. That will then be kept in your file. And if this happens several times, you would have to keep doing that. As an employee, anytime you're being accused of something that you disagree with or isn't quite accurate, you have to essentially set the record straight by putting something in writing and outlining your own version of events. What that is helpful for is that if you are in a situation where you've received many warnings and none of them are accurate, or you disagree with some of them, and then the employer uses those things as a way to let you go for cause and try to use those things to kind of build their case, as you've said, then at least as it's happened in the past, you've put forward your version of events, which put into question what they've said. You're not going to stop them from necessarily stop them from letting you go or from trying to use these things against you. But if you put these measures in place to protect yourself as an employee, you will be in a much stronger legal position later on if ever it does come to a situation where you're being let go. So Kamisha, I know we're kind of going backwards because this has all happened already, but in a perfect world going back, those are the things that should have been done. And something else I would recommend that people do when they're going through this is to contact an employment lawyer. I do sometimes speak with people who are going through this situation where they received a write-up, they received a written warning that they disagree with, and they want to know how to deal with it. And I help advise those people on how to do that. And so that's something, if you're going through this, that you can also do to make sure that you're as protected as possible if ever something worse does happen in terms of a termination taking place. For you specifically, Kamisha, the fact that you are let go after filing a complaint with Occupational Health and Safety with the Ministry of Labor, in terms of legal recourse, if you were let go because of filing that complaint, you may have a complaint or the ability to file a complaint for what's called reprisal, because employers don't have the right to discipline or terminate an employee simply because they filed a complaint with the Ministry of Labor or asserted their rights through a lawyer. Anytime an employee is asserting their legal rights, the employer doesn't have the right to basically punish them or penalize them because of it. The difficulty that I think you'll have, Kamisha, in your situation is if you've been written up many times, if you have a history of discipline with the employer, they're going to say and take the position that that's why they let you go, because you've had this history of misconduct or discipline applied to you, and that's what led to your termination, rather than your complaint with the Occupational Health and Safety under the Health and Safety Act with the Ministry of Labor. So to me, that is going to be the challenge that you might have here. But certainly, just based on the information you've provided, you may have a reprisal complaint available to you, depending on the circumstances. In addition to that, depending on what the write-ups were, you may, it may be that you're entitled to your severance. It's not clear based on the information provided whether you received a severance package or not, or whether it was offered to you. But depending on the situation, if they did let you go for cause based on the alleged misconduct, that's something that we certainly could look at and see if in fact there really was cause. And if there wasn't, then you would be owed severance. Conversely, if you were offered a severance package, as I mentioned earlier, always good to get that reviewed by an employment lawyer and make sure that the offer you've received is in line with your full termination entitlements. So certainly, Kamisha, I would recommend that you get in touch with us. We can review this situation with you so that you can make sure that you're being treated fairly and in a lawful manner. So that brings us to the end of our session for today. Unfortunately, I didn't get to any of the things I had on my list, but as I mentioned before, would much rather answer your questions. So Thank you everyone for joining us. Thank you for sending in your questions. And if you didn't get a chance to ask your question, we do have several more sessions throughout all of next week that you can tune in for and ask your question then. So that's it for me for today. Thank you everyone for joining us, and have a wonderful long weekend.